Yeah, as a result, I would like also to make a short video record in English just to inform about the processes and the ways of performance in the locked court system in Republic of Latvia, which I was fully familiar with. And I would like to add that disciplinary measures must be appointed from above personnel in the internal court system, including personal self-awareness and restrictions in use of alcohol, things like that, for the legal performance of the responsible judges in their duties. And most important is to set up stable procedure for the documentation processing in every separate court instance, so that possibility of any overtakes or possible interests of the employees would be cut off by the internal strict regulations controlled by the chairmen or the main judge in appropriate separate court institution. Without personal attitudes towards the internal underneath personnel. So that strict procedural order would be followed, and in case of any violences, appropriate measures could be appointed by such an employee who would be able to control internal order and realization of strict procedural follow-up. So far, the process of mine with applied ancillary complaint to Riga Regional Court was resent to Riga Pardaugava Court, and I have received such a reply, but temporary request and petition about the kids' custody was not included in that reply, just ignorance. Reply was provided by the civil court, civil department court chairman, without reviewing the case. It was just resent to the first court instance where actual crimes are performed. I have also received electronic reply from the highest court of Republic of Latvia about absence of competence to process applied supportive note to appeal complaint. If the highest court of Republic of Latvia doesn't have enough competence of organizing skillful court hearings, that should be changed, and the personnel must be competent enough to organize any court hearing on a possible petition, either individuals or organizational petitions with involvement of each participant on an open way in accordance with the procedures and national legislation. If the highest court of Republic of Latvia will be just ignoring such processes or trying to get away from the organization responsibilities as a highest instance in the court system, they will not be able to fulfill such function and organizing scaleful official processes at the court with the legal outcomes in any arised issues, either commercial or organizational, or the government issues, or the private issues, or individual applications. Written process is good enough for performing or for reviewing the cases with unnecessary creation of the court processes in reality. But when the involved personnel is above 3 persons, or crimes within the state organizations were performed by the interested internal personnel with possible personal attitudes, that must be taken in account by any court instance in organizing the open court hearing with open involvement in a forced way as written by law without any personal fears. That can show the power of law regarding the court power, civil process law of the court power. But if the court power will be used just for discriminational or government power offense force without legal borders within the criminal law legislation, such as criminal law article 341, the responsibilities for such an offense or deliberate use of organizational power, court's power, for certain illegal activities must be processed by the prosecution office. That is very difficult to explain but in case such concerns might be coming into national prosecution office, that kind of situations must be investigated on open way with involvement of the person or organization in concern, so that such a hard violences or criminal violences which can cause difficult consequences, really negative consequences, could be possible to investigate and appoint certain responsibility in case open investigation shows such violence in any court instance.